I'm not done, my lord.
You're done?
No.
Oh, okay, fine.
Thank you, my lord.
I thought you said when you say thank you, means you're finished.
No, I'm saying I am looking forward to receiving an unfavorable response to the answer that I've asked as a solid law. And I was saying thank you to that, my lord. Now, we further amplifying what has just been mentioned by the inherent power as follows, my lord. The provision of this section ensure that when the courts, now which section? Section 173. Ensure that when the courts mentioned therein are called upon to give effect to the spirit of the clauses of the Constitution, are not limited in their duties to do so for want of a standing procedure in circumstances where one does not exist. Now, the Constitution is the supreme authority that is superseded by none. The preamble to our Constitution states as follows, Madam, that the Constitution is adopted as the supreme law of the Republic so as to heal the divisions of the past and establish a society that is based on democratic values, social justice, and fundamental human rights. That's what Mr. Mube requests this court to accord him, not a fundamental human rights. I am also looking forward to receiving an unfavorable response to this question, my lord.
I don't know this.
Yes.
Do you know what strikes me? Because I think aloud.
Yes, my lord.
I thought it says South Africa belongs to those, all those individuals. Is that not how it starts, the preamble?
I've got a constitution here, my
No,
lord.
you said the preamble.
Yes.
Yeah, does it say that?
Let me say part of the preamble that is relevant to the case that I'm dealing with here, my lord. I'm looking at a clause that says South Africa belongs to all those who live in it. It does not say, it says we, the people of South Africa, recognizes the injustices of the past, honor those who suffered for justice and freedom in our land, respect those who have, let me wear my spectacles. Thank you, my lord. I've just worn my spectacles now. It says, respect those who have worked to build and develop our country. Those who have worked to build and develop our country, and believe that South Africa belongs to all those who live in it, united in our diversity. We, therefore, through our freely elected representatives, adopt this constitution as the supreme law of the Republic of South Africa. The court just asked me whether it says all those who belong to, believe that South Africa belongs to all those who live in it. Yes, it says South Africa belongs to all those who live in it lawfully.
Yeah.
Yes.
How even unlawful?
Yes, Mara. It does not promote illegalities or unlawfulness. It simply says all those who live in South Africa lawfully.
Right.
I may not get into the terrain, my lord, because that's not the purpose of this explanation. Now, my lord, it says that the Constitution is adopted as a supreme law of the Republic so as to heal the divisions of the past and establish a society that is based on democratic values, social justice, and fundamental human rights. Lay the foundation for a democratic and open society in which the government is based on the will of the people and every citizen is equally protected by the law. Mr. Mnube, Franite Fiel van die he does not request a lot of this world. He simply says to the court, can I please be afforded the opportunity and the necessary amenities, which are facilities, to go and prepare my defense, even before I start to cross-examine Mr. Mabaso. Because the evidence that Mr. Mabaso just came up with was a shocker to me. I have not been expecting that I'll be confronted with this evidence 23 months after the trial. He does not ask too much. He simply requests that, my lord. Now, Section 2 of the Constitution states as follows: the supremacy of the Constitution. This Constitution is the supreme law of the land. Law or a conduct which is inconsistent with it is invalid, and the obligations imposed by the Constitution must be fulfilled. Now, Mr. Nube is not standing there and saying, can you please hear me and hear me well? I am crying for the following, basing his pleas on nothing, simply basing his pleas on the Constitution of the Republic of South Africa. And Section 2 of the Constitution says that the obligations that are imposed by the Constitution must be fulfilled. Section 35(3) is a right that is imposed by the Constitution. Why should it not be imposed? Or fulfilled? Fulfilled, actually, that's the way that is used by the Constitution. Why can't it be fulfilled? Yet again, my Lord, I will be waiting very keen for an unfavorable answer to this question.
I promise you, every time he laughs, I am laughing too, because Omnisi is really going overboard. He has issued literally in this video 3 times 3 threats to the judge when he says, why can't it be fulfilled? Yet again, my lord, I will be waiting very keen for an unfavorable answer to this question, because Omnisi is holding the judge by his... Never mind. I forget. This is a kid-friendly channel. Omnisi has decided to use the oath that the judge has taken to his advantage, so that my lord is left with no choice but to adhere and fulfill the oath. Don't believe me? Let me remind you when the judge threw this at Advocate Ngomezulu, and you tell me in the comment section, what was this about? Let me insert it here.
You are saying I'm a cheat for the serious reasons. I'm concluding. I've taken an oath, if you don't know it, to administer the laws and the Constitution without fear, favor, or prejudice, and in the best of our ability. I don't know, Mr. We're going on a bar of salt.
And there you have it, straight out of the judge's mouth, okay? I have taken an oath to administer the laws. And Mnisi comes and says, the Constitution says you have to do this. And I will be waiting, okay? My lord, I will be waiting very keen for an unfavorable answer to this question, because that is a grounds for straight to the Constitutional Court. Because what do you mean you cannot administer this simple request from accused number 3, Mr. Mngube, who is not asking of the world. He is just asking to go and prepare for his defense after the surprise. Rather, how did Ngomezulu put it? No, it's not a surprise. Let's hear what Ngomezulu would have said.
Whatever information that comes after a full disclosure, after the trial has commenced, it's ambush.
Now, we further submit, my lord, that an institution, including courts, will thus not be castigated merely because that system or the court are settling for that institution or the court are settling for a system which departs from past or standing procedures in its quest to say that justice is not only done, but is also seen to be done. Those who understand the phrase justice being seen to be done, those who understand the phrase justice being done and being seen to be done would basically understand what it really means in the context of this case, my lord. Now, as we conclude, my lords, we are saying that the applicant in this matter does not request for something that is out of the ordinary. He simply implores this court to allow him to utilize his constitutionally guaranteed rights in the conduct of his defense during this trial. There is no harm which will be suffered by anyone in him being allowed to utilize the said rights. However, the opposite is detrimental, as was expounded in the Tsukutsa case, where the court held in paragraph 11 as follows: that an important aim of the right to a fair criminal trial is to ensure adequately that innocent people are not wrongly convicted because of the adverse effects which a wrong conviction has on the liberty and dignity and other interests of the accused. Now, we are saying that on the conspectus of the merits of the case and on the basis of the above mentioned, being the Constitution, being the cases that the court has been referred to, it is respectfully submitted that the applicant has successfully made a case to have this request granted by the Honorable Court. I would further add, my lord, that I think it's a point that I've already mentioned. I'm not even so sure. No, my lord. That I'm not so sure whether I've mentioned the fact that I have not even taken proper instruction from Mr. Mnyube with regard to the cross-examination that I need to have to the accused people. But if I've mentioned that, so far so good, my lord. But finally, my lord, if the Constitution was a human being, if the Constitution was a natural person as opposed to a juristic person, this is what the Constitution would have said, an open court. It would have said, dear Honorable Court, please do not be deterred or dissuaded from giving effect to the spirit of the provisions of the Constitution for a want of a specific procedure from the Criminal Procedure Act. The Constitution has empowered you, in terms of Section 173, to protect and regulate your own processes, if that is in the interest of administration of justice. And then the Constitution will close its case, will close its code. That will be our submission in support of the application by accused number 3. Thank you, Madam.
Another challenge, ma'am, is you're talking low.
You are speaking very low.
What?